Once again this month, if you go to the Wisconsin courts portion of flu, you'll notice that there are no Court of Appeals cases this month to report on. Do report on the Wisconsin Supreme Court case, the grandparent visitation case, but once again, there are not only no published cases to report on, but not even any unpublished but citable cases. And besides it affecting the information for flu, I also participate in this panel along with my friends Dennis Milbrath and Judge Tom Walsh from Green Bay, where we put on the case law update program. We're now doing it 5 times a year to both lawyers and to judges. We've shrunk the time in which we need available to present the cases and have expanded it to include new legislation. Fortunately, there was quite a bit of that this year. But the number of cases that have been coming down have been shrinking seemingly every year, and they're a fraction of what they used to be. And there are a couple of reasons for that, I think, one of which is that there's been a cultural change, I think, in terms of litigation versus settlement. And I think that's a good cultural change where people are more inclined to settle, some of it certainly due to the cost of litigation, some of it due to the fear of litigation, but hopefully it's something good in a culture where we have a lot of bad stuff going on. I started in this firm as the firm litigator and probably tried 5 to 8 divorce cases a year, and other motion hearings, first hearings, and everything else. And now probably average 1 trial a year and sometimes 1 trial every other year. We settle about 95% of our cases, and if anything, that's a conservative estimate. And what's the reason for that? Well, I think there are several. One of which is, as I said, the change in culture. But the other one is the advent of mediation. And I'm going to talk a little bit about that today. Partially, it's on my mind because I've been involved in 3 mediation sessions in the past week, all of which lasted quite a bit of time. And although only one of them ended with a kumbaya moment, well, at least a settlement, nobody joined hands in saying kumbaya, the other 2 got much, much closer to settlement, and the mediation process was a significant aid in terms of getting there. And that's something that didn't exist many years ago. When I first started as a firm litigator, nobody would have ever thought of going to mediation. And then when mediation became mandatory for placement and custody cases, people used it for that because you were required to. And now it's routine in financial cases. In fact, some judges will order it. Walworth County, it's mandatory for everyone. And in this office, we won't take a case to trial with at least offering mediation to the other side. And most times the other side accepts the offer, or they offer it and we accept it, and we end up in mediation. Its value has several purposes. I'm a huge believer in a couple of things when it comes to mediation. First of all, that for children, it ought to be mediated by mental health professionals, social workers, psychologists who are trained in mediation. These are not legal issues. There's nothing in law school about whether children should go home at 5 o'clock Friday or 7 o'clock Friday night or after school, or whether they should go back to the other parents Sunday evening or after school on Monday. It's not a legal issue. It is highly dependent on the nature of the child and the nature of the parents and the nature of parenting and other issues that are not legal in origin. On the other hand, things like support and property division really are legal issues in terms of how the law affects it, and lawyers should be mediating those, not mental health professionals. In addition, my other very strong feeling is that the concept of facilitative mediation, where the mediator just relays suggestions back and forth, is really a waste of time and parties' money. Type of mediation that we prefer is evaluative. We like mediators that'll give opinions and try to be a little bit more forceful in trying to get the parties to come to a settlement. There are 2 different types of mediators, generically speaking. There are the older lawyers and there are the retired judges. And it really depends on the individual case. In some cases, it really helps to have a mediator say, well, I don't know what your judge will do in this case, but when I was a judge, this is what I would have done. or what I would do if I was the judge in this case. And sometimes that can be very helpful. On the other hand, I'm not convinced that all judges are, forgive me if you're a judge or former judge watching this, are on top of the latest developments in the law and legislation. I think sometimes they may lag a little behind in that. But moreover, judges tend not to have as much sensitivity as lawyers do in terms of the lawyer-client relationship and the dynamics that are involved in trying to reach a settlement as between the parties and as between the lawyer and the individual client. And sometimes that's a real help to have the mediator being someone who has represented parties in that type of situation and be able to lead or lend rather that experience to the mediation. So as I said, it really depends on the individual case, which type we bring in, but I want a mediator that's not just going to relay messages, but is going to really try to lend opinions and try to get people to make the compromises necessary to come to a settlement. Because after all, the word settlement and the term compromise are intrinsically related. It's possible to get to a settlement where the other side rolls over and plays dead, but that generally doesn't happen. What generally happens is both parties have to make compromise, and a compromise is giving something up that you otherwise would want. And it's that evaluation of where compromises can be made and yet still reach a settlement where the party thinks that they've made reasonable compromises. In the best of situations, both sides think they made all the compromises and the other side made none, but we all know that isn't true. And if the mediation is done correctly, that they both made compromises. And so I think what's happened is that with the advent of mediation training, that mediators have gotten better over the years at recognizing some of these issues and at getting people to come to settlement, and combined with the change in societal attitude, where most people believe that settlement is better than litigation, virtually all cases settle. They may not settle at the mediation, but the mediation then helps the parties get closer. And by the mediation process, even if it doesn't settle at the mediation, they tend to settle sometime right after the mediation, or at the very least right before trial. And the mediation process is a huge help in that. Unpaid commercial announcement, of course it's unpaid, it's my video, I don't have to pay for it, but commercial announcement is, I do mediation, I do a number each year. The one comment I want to make is when I first started doing it, I used to tell people, well, it's going to be facilitative mediation because I got a lot of opinions, I might as well express them. And then you would say, I've never been through training, but some of the best mediators I know have been through training, whereas some of the worst mediators I've come across have been highly trained. And then about 3 years ago, I saw training, timing, dates, and all that worked out. The mediator doing the training was somebody I knew and respected, and I thought, you know what, let me see if there's anything to it. And it ended up being a really terrific experience. And I did the 40-hour training for the University of Wisconsin Extension, and I think it made me a significantly better mediator. And I remember a whole lot that happened in that training, and I've applied it to my use of mediation. So 2 messages here. If you're a lawyer in a case that likes to litigate, give that mediation a try, even if you like to, because our goal as professionals are to serve our clients and to try to get the best results we can for them. And more often than not, that's done through compromise than it is through litigation and throwing the dice on the table. And the second message is the commercial announcement. If you need a mediator, give me a call. I have a sliding scale of fees depending on the individual case, and I'll be pleased to try to help you.